All right, welcome everyone to day 3 of Small Business Festival here at T-Werx. Glad to have you all come out today. This has been an amazing week of lots of people, wonderful speakers all week long. Continuing today, we've got 3 excellent speakers that are going to be here today throughout the day. If you haven't grabbed one already, here's a schedule for this week, the remaining things that we have on the schedule for this week. Small Business Festival, we actually wanted to participate in last year, and my Facebook yesterday was funny. It showed me, what was happening last year at this time, and I was looking at it, and this was a big empty building with spray paint on the ground where the walls were supposed to be. So that's where we ended up last time and weren't able to participate in this. Last year was the first year of Small Business Festival. There was about 30 events around town at about 4 different venues. This year we have over 60 events around town and 12 different venues for this. So it's growing. Last year we were the #3 conference in the country by Inc. magazine. This year I'm guessing we're going to be #1. A couple things for today. One of the things that will help us to be #1, if you're here, you get a good quote or something today that you like, tweet it out to @SmallBizFest and hashtag SBF 2017. We're trying to trend on Twitter. We actually succeeded in that yesterday. We were in the top 10 on Twitter yesterday, so we want to keep that up all week long and really show, hey, this is something huge in Austin. This could not be without the help of the City of Austin, the City of Cedar Park, and also Capital One Spark Card for sponsoring this. This allows us to keep this absolutely free for everybody across the city. A couple things coming up for the rest of this week. The premium content actually starts later today. There's an after hours event downtown, and then tomorrow and Friday there'll be internationally known speakers down on the main stage downtown. There are tickets available. They are half price now. So you can go to smallbusinessfestival.org/premium and get those. If you choose not to drive south of 620, like many of us like to do, we will be live streaming the conference here, and we'll have lunch the next 2 days sponsored by, well, actually the next 3 days sponsored by Walls Insurance that is based here in our space. And we hope that you enjoy everything today. Hopefully you'll stay around for several things. We've got this event right after this is going to be Show Me the Money with Mr. Mike over here. And we'll have our Small Business Founders panel today for lunch, which is going to be fun, with 3 local entrepreneurs who founded their businesses here in the Cedar Park area. So it's going to be a fun thing to find out. If you've ever wanted to found a business, what are the challenges of starting with absolute zero and growing from there? So that said, I'd like to introduce my friend Jamie Whitney. Jamie is what I always coined as my favorite attorney and the coolest one I know. She is a business attorney, has got huge law firm experience, but she brings that huge law firm experience to those of us that are in the entrepreneurial community, and is an amazing lawyer. So that said, Ms. Jamie Whitney.
Thank you, Jeff. All right, you guys are probably all wondering why I left tennis balls in your chairs. And it wasn't just to keep you awake, and I hope you don't throw them at me, although I guess that's what I get for putting tennis balls in your chairs. But you'll see what these are all about in just a minute. Before we get started, let me tell you just quickly who I am and what my background is, so you can kind of evaluate the information you're getting, right? I started my legal career clerking for a federal district judge here in Austin. Then I spent several years working for one of the large international law firms that's based here in Austin on their litigation teams. So I've tried cases or been part of trial teams in federal courts, in state district courts in different states all over the country. Pretty much if you can go there and do that, I've had that opportunity with a large firm, great people to learn from. However, that wasn't really what got me up in the morning. When you are on a large firm legal team, you tend to be one cog in a very big machine. And your job tends to be, at the end of the day, kind of moving people's money around. And there's nothing wrong with that, but it's not the same thing as helping somebody with a problem that's going to make or break their business, their life. So since I've gone out on my own, I've really enjoyed being part of more intimate relationships with my clients, really getting to know them and really getting to be part of the decisions that help your businesses thrive. So that's what gets me doing what I do. And now let's talk about what that is. Anybody want to tell me what you think about when you think about lawyers and the legal system? It's okay, you won't offend me. Any volunteers?
Yeah, we will.
All right.
Conflict.
Conflict, yes. What else?
Money.
Money.
Something to avoid.
Something to avoid. Yes.
At all costs.
At all costs. Let's see, am I doing this? Oh, there we go. This is what I think a lot of people see when they think of the legal system. It's there to trip you up. It's there to make you feel stupid. It's there to disrupt your plans. Yes? Or maybe you think of getting sucker punched by a lawsuit or by a regulation that you didn't even know you needed to comply with before you get a violation notice. This is my favorite. A lot of people really do see the law as something that has the potential to destroy what you're trying to create as a small business owner. And I'm here to tell you that that is not true. It's not the case. It doesn't have to be that way. The law is actually a tool for you to grow and protect what you are building. So, what my surprise? This is what your tennis ball is for. I have in one hand an egg, and I have in my other hand a tennis ball. And I'm gonna throw them against the ground as hard as I can. Which one do you think is gonna make a mess on Jeff's carpet? Today, we are gonna learn about how to be the tennis ball and not the egg. It's a plastic egg, by the way. I like you too much for that.
Thank
you. So, life happens. You're gonna get knocked around, especially as a small business owner. There are going to be contracts that go sideways. There are going to be regulatory inquiries that make you feel uncomfortable. That's all part of the game. But if you plan ahead, if you know what you're doing, then those are things that don't even throw you off your stride. In fact, they may give you more momentum. If you build your business like a tennis ball, you can bounce back from whatever life throws at you. So let's talk about how to do that. You all have with you a little booklet that I put together that goes into some more depth about the 10 legal growth moves that we're going to talk about today. So the PowerPoint that we're using is really just to give you something entertaining to look at that's a little bit cuter than my face, and to give me some reminders about where we are in the presentation. So feel free to take these with you, feel free to refer back to them, feel free to call me if you have any questions about them. I office right here in T-Werx, so you know where to find me. Ah, that's what I thought I was going to show you. This is how we're going to think of the law when we get out of here today. It really is something that helps you to build a foundation, to grow what you have, and to protect what you've built. So let's talk about building that foundation. There are certain things that every business, whether you are building widgets or running an online consulting firm or sending rocket ships to the moon, every business needs to put these pieces of legal foundation in place. Entity formation is something you do right off the bat. That's when you make the decision, am I going to be a sole proprietor and run this business basically as myself? Or am I going to put an entity in between me and the liabilities of my business? And there are different ways to do that. You can be a corporation, you can be an LLC. If you're a professional of certain kinds, maybe you need to be a professional corporation or a professional LLC, a PLLC. Maybe you want to be a partnership. Lots of different flavors. But the basic decision is, do I want an entity and what kind of entity is that going to be? The next thing is contracts, yours and theirs. Now, you may want to create your own master service agreement or your own terms of use, your own contract that you are giving people to sign. And some of the advantages of that are that you always know what those basic terms are going to be, and you've written them so that they are terms you know you can live with. Sometimes you're not going to have that luxury. If you get a deal with Whole Foods and your soap or lotion or whatever is going to be in their huge supermarket, you're probably not going to be able to dictate a lot of the terms of that contract, but you still need to understand them. You still need to understand what it is you're getting into so that you can make a reasoned decision about whether that really is a good deal for you or not. So we're going to talk a little bit about that. Team members. Probably most of us are starting from the position of me and my laptop, and that is your team. But eventually, maybe you're going to bring on some contractors. Maybe you're going to bring on an administrative assistant. Maybe you're going to bring on some salespeople. There are all kinds of partnerships that are eventually going to be necessary to help your business grow. And there are important considerations that come into play once you start bringing other people into what you're building. So we'll talk about how to protect yourself in such a way that your team becomes an asset and not a liability. IP. IP is another situation where we need to talk about yours and theirs. One of the things that trips small businesses up, one of the few things that really is worth getting into court about for small businesses, is often IP related. Trade secrets, trademarks, things like that, because a lot of the value of your business, particularly if it's a relationship-based business like insurance or banking, or if it's an IP-based business like graphic design or consulting, all of those things, the intangibles of your business are what gives it life. So you've got to be careful about IP, both protecting your IP and not stepping on someone else's IP, because that is a hot spot. So we'll talk about that. Record keeping. Record keeping can be the tax records you need to keep, the business plan you need to keep. I mean, all the things you think of as records. It can also be things that you don't think of, and that's where you can get tripped up. So emails. What's your email retention policy going to be? Do you have a Twitter policy? Is your business tweeting as you? Is it tweeting as your business? Are your employees tweeting for your business? Thinking about records and how to manage those in a way that makes sense for you and is going to make sense if you have to refer back to those records in different contexts is something that it's very good to think about from day one. This next one is my favorite, trusted advisors. So you've heard the phrase, it takes a village, right? That's really true when what you're raising is a business. Hello. No worries. So with trusted advisors, if you come to me and we talk about a legal issue you have, it's very likely that at some point that legal issue is going to sort of touch corners with a tax issue or a financial issue or an insurance issue. And it's very likely that I'm going to tell you, whoa, hey, I'm the lawyer, I don't know anything about your finances or your tax. I went to law school because I never wanted to do math again. So I will send you to your CPA or your financial advisor or possibly Darla, your HR consultant. So what you need to build, and it may be that you need to hire all these people immediately, it may just be that you need to get to know them so that you know who you like and trust when it's time to hire somebody. But make relationships with trusted advisors so that you have a professional circle to help you make the decisions you need for your business. This next one is physical space. You may start your business on your couch. That's where Richards-Whitney Law started. But eventually you're going to want to move into a physical space. It might be a co-working space like T-Werx, or it might be a space that requires a commercial lease. It might be a retail location or a warehouse location or an office building where you're signing something that's going to last for 5 years, 10 years, and your business is growing and changing during that whole time. Commercial leases have a lot of pitfalls. They're not a bad thing. Every business is going to need one at some point. And maybe not every business, but most of the businesses that are growing are going to need a space to grow from. But before you sign a document like that, you need to be very aware of what you're signing on for. And there's some unique complications with those that we can talk about. Same thing with insurance. Commercial insurance is something that almost every business needs to consider having. If you are offering a professional service, you may also need errors and omissions or professional liability insurance. If you have folks driving for your business, you may need some, see, this is why I need to send you to the commercial insurance agent, right?
Automobile insurance.
Not just automobile insurance, but automobile insurance that's going to cover your business for their fender bender. So, insurance, talking about what you need and what it actually covers, is something that A, you're going to need an insurance professional to tell you about, but B, it's a contract, and it's a contract that you're going to read just like any other contract, and it has exclusions, disclaimers, things it covers, things it doesn't cover, and learning to parse that is something that will be helpful to you as a business person. So, moving right along, let's talk about your entity. So it's fine to start your business as a sole proprietorship. Nothing wrong with it. Lots of people do it. Don't run out of here thinking, oh crap, I haven't founded an LLC. I am doing it wrong. You're not. It's okay. The reason to form an LLC or a corporation or any other kind of business entity is because it sets up what's called a corporate veil. And essentially that is a firewall between the liabilities of your business and your own personal assets. So if you are in a business where you're exposed to risks that may be great enough that the finances of your business can't cover them all at once, and your personal assets might wind up on the table to satisfy a judgment, then yes, absolutely, you want to set up a business entity to protect against that kind of liability. It's very easy to do. It's not actually something that you need a lawyer to perform for you. It's just a sign up on the Secretary of State's website. It's a very simple form to fill out. I think it costs about $300 these days is the filing fee for most different types of entity. Now, where you may want to talk to a trusted professional, whether it's a lawyer or a CPA or whoever, is about how you're going to structure the internal governance of that entity once you put it together. Particularly if you have partners. If there's going to be more than one person involved in driving this boat, then what you'll need is a company agreement that you're putting together, and it's essentially a contract between all the founders that says how we're going to make key decisions for the company, whether that's going to be, it has to be unanimous or it has to be majority rule, or what flavor of decision making we're putting in place. It's going to talk about how new people get let into the company and how the admission of a new member might affect the membership percentages of an old member. Is it going to dilute the original stock, I guess, or control powers of the founders? And are we going to cede control to any new members? Are we going to allow new members to have voting rights, or are we just going to give away essentially financial interests in the company in the future? There's lots of different ways to do it. Company agreements are infinitely customizable to decide how your company is going to run, but they are a good thing to put in place before high stakes decisions are on the table, because they do two things. First, they give you a roadmap so that when the stakes are high and emotions are high, everybody can refer back to this document that was put in place at the beginning and follow step A, step B, step C. It's good to go in with a plan. And then the other thing they do is they give you and your partners a chance to talk up front about what your expectations are. So nobody gets surprised down the road because person A thought that we were doing X and person B thought that we were doing Y. So I highly advocate getting a company agreement in place in addition to that simple step of just registering your entity as whatever you want it to be with the Secretary of State. That doesn't really do much for you unless you also put in the work and the time to decide how that entity is going to be governed. So, speaking of no surprises and discussing expectations on the front end, who here likes to do business on a handshake? Anybody? Okay, yeah. Who here feels like you can trust your business partners and you only do business with people you feel are trustworthy? Yeah, good policy, very good policy. Okay, I'm here to tell you that that is a great policy and it is a policy that will not work. And it's not because everybody's really untrustworthy and they're going to screw you as soon as you turn around. That's not it. It's because business on a handshake is still a contract, but it's a contract that only tells you, this much of what the deal is. And both people on each end of that handshake have their own ideas about what the other 90% of the deal encompasses. And at the end of the day, if all you've got is business on a handshake, then all you can enforce is whatever you guys shook on. So say we do business on a handshake and it's for me to sell you, 30 pairs of earrings that you're then gonna go resell. And so we shake hands and a month goes by and you don't have your earrings. And you come to me and you say, Jamie, well, where are those earrings? I need to sell them. I said, well, I never have my earrings ready in 30 days. I thought this was 60 days for me to get it to you. Our handshake didn't help much at all, even though we're both people of goodwill. I wasn't trying to screw her over. She wasn't trying to rush me. We just didn't know. So always get it in writing. A contract doesn't have to be, a stack of papers that's full of whereas and whatevers. But it does need to be a document that clearly sets out the expectations of all the parties. Let's go a little deeper into that, because there are some pieces of legalese that show up in very many contracts that do trip people up. And this is your opportunity. You can consider me your legalese to English translator. If anybody has a contract term that you have seen that bugs the crap out of you because you don't really know what it means in English, or you know what it means in English, but you suspect it may mean something completely different over in legal land, now is the time. Any examples? I'll start with one.
Must and shall.
Must and shall are good ones. Must and shall. And I'm going to tell you a secret. Must and shall are important because they do mean exactly what you think they mean in plain English. This must happen in order for compliance with the contract to have occurred, right?
How about must and shall and may?
May does not mean that it must happen. May is a squishy, wiggly term, and if you see may in the contract, you should consider that an expression of the party's good faith that you are not going to be able to enforce. Although, if you're the one who may do something, I would recommend that you go ahead and do it because you're going to have to pay me a lot of money to not enforce it. But when we're talking about must and shall, at the end of the day, must and shall tell you what needs to happen in order to comply with the contract. But if must and shall don't happen, then what you have is a breach of the contract. The contract has been broken, and whatever those remedies for breach are that we can talk about later will come into play. There's also language that you may see that says not only is there something that must happen, but that thing is a condition precedent to the other person's obligations in the contract. And that's a little different and even a little more serious, because if it's a condition precedent, then that other person doesn't even have an obligation to fulfill until that thing that is a condition precedent happens. So if we go back to our earring deal here, if we actually did a contract and it said those earrings must be delivered within 30 days and I didn't deliver the earrings to her, well, whatever our termination clauses said, maybe she would have to pay less for the earrings because I could get them to her in 40 days or whatever, right? But it would be determined by either what we agreed on or sort of what her actual damages were from getting the earrings a few days late. If it was a condition precedent to the contract that those earrings have to reach here by this date, and only if the earrings reach here by May 2nd will I pay you anything, then the fact that the earrings didn't get there on time means that I don't have, game over. There's no contract. And nothing else that may have been in the contract will have any effect. So whenever you see the words condition precedent, it's not a red flag in the sense that, oh, you should run away, and it doesn't mean anything nefarious. It just means this is really important. This is something you need to pay attention to, and you need to make sure that this condition precedent is something you reasonably think can happen, and can happen in the order that's specified in your contract, if you want this to be a good deal. Any other legalese terms that have popped up for you that you would like to translate here today? Okay, so I'm going to give you another one. Who here has signed a contract with an indemnity clause, indemnification? You will, at some point, because everybody loves these. So another term you see frequently, along with indemnity, is waiver. And waiver, in a contract sense, often means that you and I are going to agree that whatever claims we may have against each other for this, that, and the other, we're going to put them aside. We're not going to sue each other. We're going to waive those claims. However, just because we have a contract, if something that we do, particularly if there's a distribution chain or a chain of contractors and subcontractors, if there's anybody else out there who may have a stake in what we put together with our little contract, if it's harmed them in some way, they're not going to care that I waived all my claims against you for this, that, and the other. If they have a claim, they're going to bring it. So a lot of times what a contract will include is an indemnity clause. And indemnity is a way of saying that I am going to pay the damages and expenses and legal fees for a lawsuit that you may bring against him because he's using those earrings that I sold him and they made your ears turn green and fall off or whatever. So indemnification clauses are actually, they're a good thing. They make a lot of business possible that wouldn't otherwise be possible because they allocate risk. They let everyone know what to expect. But you need to read those indemnification clauses carefully because they often have the effect of putting you on the hook for something that's not really in your control. So if you see phrases that say you're going to indemnify somebody else for their own negligence, you know, that's a big undertaking for you. That's a big chunk of liability to take on because you don't have any control over whether they're going to do things in a careful and workmanlike manner. So indemnification clauses are definitely something to read closely and possibly get an outside set of eyes to look at with you to make sure you know what you're signing on for. The only other thing that I see show up in a lot of contracts that I want to flag for you in this sort of legalese to English translation portion of our day is choice of law and venue provisions. You see these in lots and lots and lots of contracts. Has anyone ever signed a contract that says any disputes between you and whoever are going to be arbitrated or litigated or whatnot in New York or Florida or whatnot? It may make a lot of sense for them if their company is headquartered in New York or Florida or wherever, but how are you going to manage going to New York, you know, for every hearing in that case? It can wind up being a real barrier to protecting your rights in the event that you have to do so. So when you're signing contracts, look out for choice of venue, choice of law clauses, look out for indemnity clauses, look out for disclaimers, representations and warranties. Those are the things that people are either saying they will do or saying they won't do. And so that's kind of the 90% of the deal that is underneath that handshake. That's in all of those different contract clauses. And believe me, that whole idea that's kind of grown up in popular culture about making a deal with the devil and having to read everything, you know, super, super closely because otherwise you will find out that you've given away your firstborn child. You know, that's not what we're talking about. Most contracts are written so that both people can walk away from the table feeling like they've got something of value. All I'm saying is that you need to look at all of the terms of the contract and you need to think about how those terms are going to play out in the what-if scenarios so that you can make sure that you're walking away from the table with exactly what you intended to walk away with. So any questions about that before we move on? Yeah.
So as a small business owner, like I've seen almost 90% of the contracts, you know, they have this clause, you know, like, and if I'm dealing with a consultant from like California, Seattle, you know, all cases would be held there or here. And if you're dealing with an entity which is bigger than yours, how do you tell? I mean, I've tried telling them, hey, we won't do this, but they are like, no, this is it. You know, this is it. We won't change it. So what do? Do you stall your business progress, or do you like?
No,
so how do you handle that?
There are definitely going to be situations, and probably lots of situations at the beginning of your business, where you don't have a lot of bargaining power, and the contract is a take it or leave it contract. And so your goal in reading through these provisions is to think about, okay, well, A, would the worst case scenario under this contract tank my business? And B, what's the likelihood of that worst case scenario in comparison to, you know, the business benefits that I expect to come from this contract? And it's perfectly possible to make a reasoned, legitimate business decision that is not the 100% best, contractual negotiation from a legal standpoint decision. As long as it's legal, as long as it works for your business, absolutely do what's best for your business and don't worry about what the law school professor would say. But do read it first so that you can make a reasoned decision about what that is. And then when you do get to the point where you can have someone signing your MSA, write these the way you want them. Where'd my clicker go? Here we go. All right, so, okay, now let's talk about employees. This is something, and if you came to Darla's presentation yesterday, did you touch on this at all, Darla? Okay, so this is something that your legal professional can tell you a lot about, your HR professional can tell you a lot about, and it's something that you need to have in mind from the very first person you bring onto your team. Most federal labor laws don't apply until you get to a pretty high head count, usually about 15 team members. But there's one, the Fair Labor Standards Act, that applies as soon as you bring somebody on to work for you. In fact, even if you have a nanny working for you at home, it applies. And that is this idea that if somebody is your employee, you've got to pay them the minimum wage, and you've got to pay them overtime for hours that they work in the week, over 40 hours a week. And it becomes important because those rules don't apply to contractors. And so it's very attractive for small business owners who are trying to build a team on a shoestring to characterize people as contractors. And if that's a legit characterization, then it is great. It helps you grow your business, it helps them grow their side hustle, everybody's happy. If it's a gray area, if that's a shady characterization in any way, it can get you big trouble. And I'm sure you guys have all heard about Uber's giant lawsuit over whether drivers should be classified as contractors or employees. It also hits much bigger, older companies. FedEx recently settled one for millions of dollars. So this is a characterization issue, whether your person is an employee or a contractor, that you just can't mess around with, because this is a potential business ender. You know me by now. I'm not into trying to scare you or show you the boogeyman under the bed, but classifying employees is nothing to mess around with because it can tank you. So how do we classify our employees correctly? It all comes down to control. If you are telling somebody where to be, what to wear, and how to greet your clients, and how many things to put on your shelf in which order, they are probably your employee, even if they're only part-time or a part-time employee. If somebody is maybe doing a little bit of code for you a couple of hours a week, or even 40 hours a week, but they are also doing code for 10 other people, and they have their own business, and you're actually paying their LLC instead of paying them directly, chances are they're a contractor. It's a very fact-specific determination, which basically means you make your best guess now, you document it really well so it's defensible later, and then if somebody gets terminated from your organization and files a claim, or if the IRS disagrees with your classification and wants to talk to you later, or if the Texas Workforce Commission comes back and says, hey, we don't want here, then you provide that documentation, you provide your justification, and you say, look, this is what we thought we were doing, and this is why we thought it was a good idea. So my recommendation for you is anytime you're contemplating bringing somebody onto your team, talk to one of your trusted professionals, whether it's an HR person, whether it's an attorney, whether even a CPA can be helpful sometimes. But you want to know what it is that these various people who may someday second guess your decision are going to be looking at, so that you can check off those boxes and make sure that you know exactly why you are making the right classification, and you can explain it to someone else later. The other thing you want to worry about with employees, not want to worry about, but just want to be protective of with employees or contractors, is setting out clear expectations from the beginning about who's going to own what and who's going to bring what to the relationship. Particularly if you're running any kind of software or consulting or graphic design or any kind of intangibles company. When you bring someone new into your company, you want to be sure that they are not bringing with them a customer list that they built up at their former employer. Because their former employer may then be coming to you and saying, hey, you stole all my customers and you induced my employee to take them away from me. You have deeper pockets than my employee, so I'm going to sue you for that. Same thing with trade secrets or processes, designs, anything like that. So when you bring someone on, it's a very good idea to have a clause in the agreement bringing them on, whether they're coming in as a contractor or an employee, that says, hey, you represent you're not bringing anything from anyone else. You don't want anything from anyone else. It's only your own stuff. We are not hiring you with any intention of poaching from the place you came before. You also want to get clear, particularly if you're getting any intellectual work from them, about who's going to own what they are doing. And so it's a good idea for you to include clauses that say, anything you do for us relating to our business during the time that you're here is stuff that's going to belong to us. To the extent possible, it's going to be a work for hire. If it's something that has to be licensed, you are giving us a paid up forever license to use it. Vanguard, and there are ways to DIY any of this stuff. The reason to build yourself a team of trusted advisors is to look for the value add that you can get from having someone who's steeped in that particular area who can help you figure out what's going to help your particular business. You're the expert in your business, so draw on expertise that will boost your own whenever you can. So one of the last things we're going to talk about is commercial real estate. At some point, many of you probably will enter into a commercial real estate agreement. And these are just contracts, like any other contract, but they tend to be very long, very complex, and they tend to lock you in for a very long time. Has anyone here had a commercial real estate experience? Yeah.
Yeah, so the long contracts and stuff which sound as if they are just there to get you. I mean, like for every small damn fault, the onus would be on you.
Yeah.
So we were trying to open up a restaurant, and there was a 10-year lease, and they were like, yeah, like 10-year lease, but that was okay, but the contract was based like, say for external forces, there is damage to the property, they could come after our entire business. And it makes it even more difficult when the landlord is in corporation.
Yeah.
So it's like, it's not a physical person, who understands small business. It's like corporation, people working for corporation, they just don't want to deal with any changes to contract. And what it is, this is what it is.
Yeah, absolutely. So what I hear you saying is that you got into a commercial lease and then you felt like there were a lot of gotchas in the lease. And anything that went wrong was on you. The landlord wasn't to be relied on for anything. And that it put your business at risk in some ways. Is that fair?
Yeah.
Yeah.
So we didn't get into that lease because of the landlord being a corporation.
Good. So you dodged a bullet.
Yeah.
And that's exactly the issue. Commercial leases are good. You want a retail space, and the only way that that arrangement is financially viable is if a corporation who is managing the space or a landlord who's managing the space can get some predictability and can know that they're going to get their rent back, particularly if they're giving you money to build out the space. So it makes sense that these are, tightly written contracts that last for a really long time. But if you don't know what you're signing on for, it can be full of gotchas. And frankly, some of the contracts that I've read in this area are so slanted in favor of the landlord and away from the tenant that that it makes more sense to walk away than to sign on for that. So when you're going through a commercial lease contract, you want somebody who is purely on your side. You want somebody who is not trying to get you into that building to look at this with you. Maybe it's an attorney, maybe it's just a friend who is comfortable, going through those 20 or 30 pages with you. But you want to know what the CAM charges are. If
What's CAM?
CAM stands for Common Area Maintenance. And so there are a lot of different ways. Exactly, it's pass-throughs. And there's a lot of different ways to write a lease, but a lot of those variations on the theme include a way where you are going to be paying for common area maintenance, meaning repairs, meaning increases to the property taxes, meaning if the state comes by and says, hey, you guys don't have enough ramps in your parking lot and you need to repave and rebuild the whole thing to accommodate the ramps, you know, those costs are going to get shared out among the tenants, which is all well and good, but you need to know what those are. You need to know how they're going to be assessed. You need to know how fast they can go up and whether there's any cap on them. Because all of that is money you're going to owe in addition to your rent. And so if you're thinking, oh, well, this place is great, my rent is $5,000 a month, but really you're also going to be paying, you know, $8,000 a year in CAM charges, whether that's one lump sum or added on every month, you know, that's a very different number than you're budgeting for. So you want to know what those are. Indemnification, same thing we talked about before in respect to just general contracts. A lot of commercial leases will ask you to indemnify the landlord, not just for things that happen on your controlled portion of the property or things that happen, you know, with you and your contractors, but also for the landlord's own negligence, the things that happen in the common areas of the property, which is great for the landlord, that sets their expectations, but it means that you may wind up on the hook to indemnify a loss that you had no control over. Someone slips and falls in the parking lot, you know, 30 feet away from your business, and it's still your problem. So that's something you need to watch out for. And then there's termination remedies and subletting. You know, if it's a 10-year lease and you get to year 3 and your business is just, it's not working. You've grown in a different direction, you need to be in a different part of town, you know, whatever. How hard is it going to be to get out? Can you find someone to sublet, or is there an absolute prohibition on subletting? You know, and these are written to be long-term leases, so a lot of times those termination clauses won't have a lot of flexibility. That's just part of the game. But you need to know that, and you need to know what you're getting into before you sign. So commercial leases are a great time to talk to pretty much anyone who's on your team. Your attorney, your financial advisor, your tax advisor. You want to know what the effect of that is before you tie your business to it, because it can be one of the highest dollar and longest term commitments that a small business makes. Any other questions in that regard? Okay. And last but not least, insurance. A good contract and a good entity will do a lot to head conflicts off at the pass and to protect your personal assets. But at the end of the day, the only thing that can protect your business from paying dollars to defend a claim and from paying, you know, essentially all of the nuisance dollars that go with any legal dispute is good insurance. There's lots of different types of coverage, and so one of the people that you want on your team is an insurance professional who will tell you exactly what you need. And then you also want to look at those contracts and vet them with a legal eye to see what it is you're actually getting. Because most contracts, and it's not a bad thing, it's just part of the industry, most contracts contain exclusions, and they may be excluding the exact thing you thought you were buying coverage for. For example, if you get a general liability, CGL contract, right? Those are very common if you're building a project. Well, you would think that one of the things those cover would be negligence, right? Maybe the house was supposed to be 8-foot ceilings and I accidentally only put on 6-foot ceilings. That's actually one of the things that's explicitly not covered in your standard CGL policy. If you screw it up, if it's your mistake, you're not insured for that, you're on the hook. So you want to make sure that you know what your coverage actually covers, and if there are, you know, different riders or extra policies that you can buy to extend that coverage, you want to make a reasoned business decision about whether that's right for you or not. Any questions about that? Okay. That's me. That's how to get a hold of me. Would love to hear from any of you. I hope you'll take the binder and the tennis ball with you, and have a great rest of the day.
Thank you.